specializing in elder law. So he's been really delightful to work with, and for him to take the time to come down from Tucson foothills to be with us is really a wonderful gift. I do want to tell you that we have a couple of things coming up. Pam and Gary Chambers are trained in stress busting, which is a program for caregivers, family caregivers, people with dementia. And it's a 9-week program. It's a wonderful support structure program. And they're going to be starting another group very soon. So there's a special sign-up sheet over there, the white paper. If you're interested in that, please sign up for that, and they'll be in touch with you. They were going to be coming today. They may be just running a little bit late, but we'll introduce them at the end of the hour. The other thing is our upcoming forums. We will have next month Bonita Gordon with us, and Bonita is here. She is a nurse practitioner and specializes in stroke victim care as well as dementia care. So Bonita is going to be talking about diagnosis and treatment. She is our nurse practitioner. Please think of that coming next month on the 4th Thursday of the month. That's when we meet every time. And then 2 months from now, in February, Dr. March, yeah, Dr. Domer, Dr. Timothy Domer will be back with us. We've had him several times. He's a very popular and good speaker, and he will be talking about a topic related to dementia also. He hasn't come up with finally exactly what it'll be, but so that's our upcoming program. So with that, I am delighted to have, yes?
Can I just mention about
Yeah, Shani.
Yeah, sorry. I don't want to take away this.
No, that's okay.
Hi, I'm Shani Schmidt. I'm the parish nurse at Lutheran Church of the Risen Savior right up the road. And on February 25th, we're trying to get this organized with many of the churches. And Dr. Timothy Domer, the same one that's coming here, on February 25th at 9 in the morning, he is doing a lecture that he's been really wanting to give, and that is healthy nutrition for living longer. And he's not going to just get into this food's good and that food is good or bad, whatever. He is going to get down, if you've heard Dr. Domer before, he gets down to the molecular level of our digestion as we age and how we have to adjust ourselves accordingly. And how this prevents us from getting into that program of dementia. Thank you. February 25th is a Tuesday morning, 9 o'clock.
Thanks.
Where is it again?
Lutheran Church of the Risen Savior.
Risen Savior, which is just up the street. Yeah.
So
So Will and Shani, if you give me that
You
email,
will get the email.
I'll get an email from you, and then I can send it out to this group. So, and I'm delighted, Mr. Fleming, doctor, I guess.
I have a doctorate.
Okay. That he's also agreed that his presentation today will be recorded, so it'll be on our website, so you'll have a chance to see it or share it with others. So with that, Mr. Fleming, thank you.
Thank you very much.
All right, you're welcome.
I guess I'm now constrained to introduce myself by saying that I not only have a doctorate of laws, a JD, but I also used to be a judge, and I have an older brother. You know how older brothers are. He has a doctorate in chemistry. So one time I go home to visit my parents, I open up their phone book. You all remember phone books? Opened up their phone book, and he had written Dr. Ron Fleming and his phone number. So below that I wrote the Honorable Dr. Robert Fleming. I am an attorney in Tucson. Foothills, when Jerry said he came down from the foothills, I thought, oh, that's not me, but it actually is. Our office is on the edge of the foothills at Campbell and River, but I'm a downtowner. I've lived in the West University neighborhood for 46 years. Almost longer than I've been a lawyer. I've been practicing law in Tucson for 49 years this year, working on 50 so that I can, once I've done 50, I figure it's no longer practice, it's the real thing. And then I'll have reached some important benchmark, but I've got a little while to go still. I do a lot of things that we might call elder law, we might call estate planning, here's what I think we're going to talk about. This is what I'm sketching out as my roadmap. This is a lot of stuff, so we're going to do kind of high-level looks at all these things, but I'll go where you want to go if you have questions. So please feel free to interrupt, ask your questions. If your question tends toward my mother signed a power of attorney naming my brother, and he now, I'm going to stop you and say, you know what, let's talk afterward, and let's not burden everybody with your individual family story. But sometimes the family stories enlighten everybody about an important element. So I won't cut you off for a little while, even if you start asking questions about your individual circumstance. Here's what I think we're going to talk about. I think we're going to talk about powers of attorney. Everybody knows all about powers of attorney. You all have them. You all have been told you need them. But I'm going to kind of demystify it a little bit and explain what they are and what the significance is and whether you need one. Spoiler alert, the answer to that is yes, you need one. Everyone in this room needs a power of attorney, needs two powers of attorney. I'm going to talk to you about guardianship and conservatorship, a little bit about the process, how it works in Arizona. Oh, and I need to say that I'm an Arizona lawyer. Oddly, I am also admitted in Montana, but I've never practiced in Montana. I only got admitted because I was from Montana and my mother wanted to go to the swearing-in ceremony. She was also a Montanan, so I got admitted, but I don't really know anything about Montana law either. Sometimes I know the ways in which Arizona law is different from other states, but not reliably. So everything I tell you will be about Arizona law, and with the disclaimer that your mileage might vary. If you actually spend 7 months of the year in Iowa, you might not want to take everything I say as gospel because, can I say that in this room? Because I don't know Iowa law. But I do know about guardianship and conservatorship in Arizona, and so that'll be our second topic, I think. I'll talk generally about estate planning. I could do do you need a will or a trust, and what's the difference, and what do you need to do for your estate planning? I can easily do an hour session on that and run out of time. So I'm not going to go that deep into it. That's not what I understood you all expected to hear here today, but we'll touch on it a little bit at least, because it's involved. And we'll spend a little time on long-term care costs. Again, that's a kind of an hour-long presentation of it in its own right, and even then, I make a joke with my clients when I talk about long-term care costs. You can sit and talk to me for about an hour. We can go through your individual circumstances. You'll scratch your head as you're walking out of my conference room and say, well, that was complicated, but I'm glad I did that because I kind of understand it. And it turns out there's something magic in car seats, because the minute you sit down, it's all gone. And that's because it is not intuitive, it's not logical, it's a bunch of numbers, a bunch of rules. So I'm not going to try to burden you with all of that detail. We're going to do very high level on the long-term care costs. And then I'm weird. I really like end-of-life issues. By that I mean burial, assisted suicide, cremation, the things that really are truly end-of-life issues. So that's for me at the end, because I enjoy doing that. We may not have very much time to talk about that, but you all want to know about human composting, right? Yeah. Who doesn't want to know about human composting? Powers of attorney. So you might hear about powers of attorney and think, well, do I have the right one? Oh, somebody said durable power of attorney. Does my power of attorney need to be durable? Wait, what's the difference between a healthcare and a financial power of attorney? So let me start by saying something that isn't about powers of attorney at all. Arizona law says if you didn't sign a power of attorney, a healthcare power of attorney, and you don't have a guardian making decisions for you, but you're an adult so that nobody else has the implicit authority to make your decisions for you like you would for your minor children, still immediate family members have the power to make healthcare decisions for you. That's a great relief for a lot of people who never got around to signing healthcare powers of attorney. Now, there are two giant problems with that. Well, I suppose you could say three. One is that if you happen to drive to Iowa, again, disclaimer, I don't know what Iowa law is, but if you happen to drive to Iowa, that rule might not work the same way. But the two big problems in Arizona are they have a definition, a checklist of who's next on that list, and we have to follow that list. So if you were not going to name your spouse as your healthcare agent, and you didn't get around to signing a healthcare power of attorney, bad news, your spouse is the person who has the power to make decisions for you. If you don't have a spouse, it's your children, or a majority of your reasonably available adult children. Now that's what most of you would do when you sign a power of attorney, so maybe that's not awful. The second big problem with that Arizona law that allows somebody to make decisions for you is there's one giant carve-out. The Arizona legislature is pretty worried that we're all trying to kill our parents. So they don't give you the power to withdraw life-sustaining treatment like food and fluids. And I'm going to bet that if I polled all of you, I'm not going to do it, but if I polled all of you, most of you would say that's, in your mind, one of the most important things, is the ability to withhold food and fluids. And the person who's acting under that statutory authority can't do that. So that's why you sign a power of attorney. That way you get to pick who is going to be your agent. You get to give them the power to do that, or tell them that they don't have the power. You get to customize your document the way you want it to be, and that's true for both healthcare and finance. Conventionally, there's no law requiring this, but conventionally, lawyers in Arizona tend to do those as two separate documents, a healthcare power of attorney and a financial power of attorney. By the way, a word about the word durable. People say it's got to be a durable power of attorney, and that's true. At common law, so this is how old I am. When I went to law school, I was learning about how powers of attorney automatically end with the incapacity or death of the person who signed the power of attorney. In Arizona, we changed that rule in 1974, just as I was finishing up law school. Well, I wasn't even finishing up. I was halfway through, I guess. And we said a power of attorney can continue even after you become incapacitated, so long as it has magic language in it. It has to either say, this power of attorney will survive the disability of the principal, or this power of attorney will become effective upon the disability of the principal. Doesn't have to be exactly that language, but language similar to that. And that makes it a durable power of attorney. That's the magic of durability in a power of attorney. Today, 50 years later, I defy you to find a power of attorney that is not durable. They all have that language, except in the rarest of circumstances. In fact, in a lot of states, not including Arizona, if you don't have the language, by default, the power of attorney is durable. So you can stop worrying about whether your power of attorney is durable or not. It almost certainly is, and even if it's not, it's going to be treated as if it is. But a healthcare power of attorney gives somebody the power to decide where you live and what medical care you get. The financial power of attorney gives somebody the power to handle your finances. And we don't have a law about handling finances that's parallel to that one about the healthcare. So if you don't sign a financial power of attorney, nobody, not your adult children, not your spouse, not your mother, nobody has the power to handle your finances for you. If you're married, probably everything's in joint names, and so the well spouse, and you're going to hear me talk about the well spouse a lot. By that I mean the one who is not so disabled that they can't make their own decisions. Doesn't mean that you are truly well, necessarily. But the well spouse may be able to manage things as a matter of fact because they're on the accounts as well. But there's no inherent power to make financial decisions for the other person. So you really need to do a financial power of attorney. And you really need to do a healthcare power of attorney as well, so you're not stuck with the limitations of the Arizona law. In order to sign a power of attorney, pretty straightforward. It just has to be clear that that's what you mean. That durability thing, you got to decide, is this power of attorney going to exist now and continue if I become incapacitated? Or is it only going to spring into existence upon my incapacity? Lawyers who work in this area refer to the latter as a springing power of attorney. It springs into existence. And the former, one that continues after your disability, as a surviving power of attorney. Which one do you want? And I know exactly what you're all thinking. Well, I want a springing power of attorney. I don't want anybody to be able to make decisions for me unless I'm incapacitated. And my stock answer to that is, so let me see if I get it. You trust your daughter to handle your finances if you're not well enough to see what she's doing, but you don't trust her to handle your finances when you can see all the accounts and ask her questions and talk about it. Do I understand that right? And what I'm really saying in the back of my mind is, please don't make me sign a springing power of attorney or prepare a springing power of attorney for you, because it's impossible to get the doctor to write a letter that turns your springing power of attorney into an active thing. First of all, most of you aren't sure who your doctor is. And then if I call your doctor and say, hey, Mabel is losing it, she signed a power of attorney, we need a letter from you, he's going to say, lawyer? I don't take calls from lawyers. If your daughter calls your doctor and says, my mom needs a letter, he's going to say, I can't think of how to code for that to get Medicare reimbursement. You know what? I'm not a psychiatrist. Why don't you talk to a psychiatrist? Well, she doesn't have a psychiatrist. Look, I'm just whatever. I'm just an oncologist. I don't know anything about it. So it's really hard to get those letters. So please, if you do have a springing, financial, durable power of attorney, rethink it. Let's talk to your lawyer about updating it to getting a surviving version. Requirements for execution, though, are dead simple, no pun intended. You just sign, have 1 or 2 witnesses or a notary. Why not have 2 witnesses and a notary, just so that you've got all your bases covered? That's our usual style in law offices. Of course, we are awash in witnesses and notaries. That's not true for you sitting in your casita going down to the bank to try to get somebody to notarize it. But if you can, let's have 2 witnesses and a notary. Your agent on either a healthcare or a financial power of attorney is what we call a fiduciary. Their duty is to you. That doesn't give them the authority to steal your money. It does give them the power to steal your money, let's be honest. They could use the power of attorney to empty your bank accounts. But if they do that, they'll have committed a crime and you could sue them. Well, that's faint help if they've taken all your money and you're about to be thrown out. But understand that they don't get to just make all their own decisions about how they would like to use your money. Unless your power of attorney has given them the power to make gifts to themselves. And a lot of powers of attorney do, and for good reason. So that's something you want to talk to your lawyer about while you're getting ready to do a power of attorney. The agent on a power of attorney, a financial power of attorney, has an obligation to notify you, to account to you, to give you information, to answer your questions about the use of the money. Of course, as they begin to do things using your power of attorney, you probably are at a phase where you're beginning to lose capacity. And so the requirement that they share things with you is hard to discharge. They don't want to print out a copy of your statements and an accounting and hand it to you in the nursing facility for you to put on the table beside the bed and have the nurses read and have some other resident pick up and wander off with. So it's a challenge for them to get you the information you're entitled to, but you are entitled to that information. And here's a big problem. A lot of people name their spouse as their agent on both a healthcare and a financial power of attorney. And maybe they name their oldest child or their child who's a doctor or their child who's a banker or somebody as the alternate. And then their spouse dies and their daughter or their son moves to Kansas. We'll skip Iowa for a while. They didn't make it all the way to Iowa. And there's nobody who's really available to act. So don't hesitate to name 3 or 4 people. There's no easy way to your first agent can't designate their own successor. So you need to have a succession plan in the power of attorney. It's almost never good enough to just name 1 person. You really need 2 people at least, and at least one of them needs to be the next generation, somebody who's not as old as you are. And it'd be great if you had 3 people, at least 2 of whom are of the next generation. That's all I'm going to say about powers of attorney, unless you have questions. Yep.
I understand that Arizona is one of the only states that has a mental health power of attorney. Do you know anything about that, or is it?
So there is something called a mental, and I'll repeat the questions for you. The question is whether Arizona is a state that has a mental health care power of attorney, and Arizona does have such a provision. It's not correct to say we're one of the only states. It's reasonably common, but it is not universal. So we have a power of attorney, a separate document or a provision inside your healthcare power of attorney that you can separately include. It doesn't have to be separately signed or initialed or anything, just have to have separate language that gives them the power to make decisions about your mental health care, to lock you up in a psych ward, to be blunt about it. Now, most of you reasonably would say, I've never had a day of mental health issues, and I don't know why I would sign that. Here's why I urge my clients to sign it, even though it may make them a little bit uncomfortable, is because dementia often presents itself as a behavior disorder. And that may mean that you have to be hospitalized briefly, usually for 3 or 4 days, to get you stabilized, to get medication started, and then you can be discharged to an appropriate facility. If they don't have them, if nobody has the power to make mental health decisions and lock you up in that psych ward where you're getting that 3 or 4 days during your behavior break, then they have to do a civil commitment proceeding, which you probably would just as soon not have to go through. The reality is, once they start the civil commitment proceeding, they'll have the authority to treat you, and the treatment will take less time than it takes to get to the actual hearing, but still, it slows down the process, makes it more complicated, and creates a lot of anxiety in the family. So people ought to sign mental health powers too.
Does Alzheimer's qualify as mental health?
So the question is if Alzheimer's qualifies as a mental health diagnosis. It's not so much the diagnosis as the behavior. And yes, patients whose only diagnosis turns out to be Alzheimer's frequently become combative early in the treatment process. Yeah, you know that, as many of you do, no doubt. I don't mean to say it's universal. It's not always combative, and it's not always to the level of psychiatric involvement, but it can be, and not uncommonly is. You know what I didn't say anything about, and I promised earlier I was going to talk about it, so let me do that now. I didn't say anything about living wills. A living will is a separate kind of thing, can be a separate document from your healthcare power of attorney, or it can be embedded in your healthcare power of attorney. And a living will is a document that says, you know, I've given my wife Rhonda, I pick on my family a lot, so for those of you of my age, you might be charmed that I'm married to Rhonda Fleming. I give my wife Rhonda the power, yes, when I signed checks at the grocery store back in the old days, the clerks often said, wait, are you married to the Rhonda Fleming? And the answer is yes. So I give Rhonda the power to make decisions for me. That's the healthcare power of attorney. And then separately, I tell her, these are the decisions I want you to make. Very potent to do both. In our practice and in most lawyers' practices, they combine them into a single document, but the living will provision is a little bit of a separate thing. So in our case, we have a healthcare power of attorney, a living will, a mental health care power of attorney. We have a driving power of attorney. Bet most of you don't have that. That says Rhonda is also the person who gets to tell me when I have to stop driving. And we may talk about some other things as well. Particularly, one of you came up to me before we started and said, what about the 5 wishes? Is that a good document? Will that work? I'm a huge fan of the 5 wishes process. I am less of a fan of the 5 wishes document. I think it's great if you fill it out, but if you have a healthcare power of attorney already, please, please, please don't sign the 5 wishes at the end. Because what you're doing is revoking your old healthcare power of attorney and replacing it with a form document that was generated by a group of very well-intentioned people in Florida who don't know a thing about Arizona law and did not have the conversation that you had with your lawyer before doing the healthcare power of attorney. But the process is terrific. It gets you to think about what kind of care you want. It gets you to talk to family about what kind of care you want. And that's the most important thing about powers of attorney, is communicating your wishes to the family, to the people who are going to be exercising the power of attorney. And critically, to the people in your family who are not given the power. They're the ones who are going to intervene. They're going to file a court action, and they're going to say, I know mom never meant to allow my brother to kill her. She would never have done that. And if in fact you want to give your son the power to withdraw life-sustaining treatment, the person you most need to tell that to is not your son, it's the other kids who are not being given that power. You need to talk to your son too, of course. Any other questions about powers of attorney? For people who never signed powers of attorney, there is a system, it's called guardianship and conservatorship. In Arizona, and this is pretty state specific, so be very careful about talking about this with your friends in California or Connecticut, where I happen to know what language they use. In Arizona, we talk about guardianship of the person and conservatorship of the estate. Two different roles. Usually, when somebody's appointed, they're appointed in the same proceeding, might be two different people, could be one person who is both guardian and conservator. The process looks very similar, but they're very different powers. If you have signed powers of attorney, probably nobody ever has to do a guardianship and conservatorship. In fact, your healthcare power of attorney probably nominates somebody to be your guardian. So if a guardianship is ever needed, the person who's named in your power of attorney has priority for appointment. Same thing for conservatorship and your financial power of attorney. It's a very cumbersome process. It doesn't happen automatically. It requires doctor's reports. It requires a court-appointed investigator to come out to where you live and write a report. It requires an attorney to be appointed to represent you and to tell the judge what you want, not what would be best for you, but what you want, if you're able to communicate that at all. And because of, and by the way, that hearing is going to be 3, 4, 6 weeks after the petition is filed. So it's a long process, involves a lot of players. You're going to, when you're getting guardianship or conservatorship over your spouse or your parent or one of your kids, you're going to have an attorney. They're going to have an attorney. There's an investigator. There's a doctor's report. There's filing fees. I usually tell people, assume that by the time it's all done, the total cost is going to be in the range of $5,000 to $10,000. That's a pretty broad range, but it's a big number. And assuming that the petition is granted, the court's view, your view might be, oh good, I got appointed my husband's guardian and conservator, I can make decisions. The court's view is, they're your husband's guardian and conservator, and they've just delegated the hard work to you. They want to see accountings, they want to see annual reports, they want to challenge you if anybody raises any questions about what you've done. It's not that you are given free rein, you're just given an entree into the courtroom. In a minute, I'm going to tell you that probate has a very bad name, undeservedly so. That probate is not awful. But this happens in probate court, and it is as bad as probate itself's reputation. It's much to be avoided if you can avoid it. Process has to be a petition filed, filing fee, served on the person. That means a service of process fee. All those people are appointed. I have a case right now in my office where a woman called up and said, I need to talk to you. I have a power of attorney for my family member, and I need to get a guardianship. And my intake person said, why, if you have a power of attorney? And this woman said, because when I tell him that he's going to have to go to the nursing home, he's not going to go, and I need a guardianship in order to make him go. And we said, well, not sure that really helps, but let's make an appointment. It'll take you 2 or 3 weeks to get in. So today we found out that she rushed down to the courthouse and filed an emergency guardianship because we didn't respond fast enough. And we had to say, you know, you don't have any more power to chain him to the bed in the nursing home as a guardian than you do as agent on his healthcare power of attorney. Well, if I tell him he has to go, And he says, no, if I'm his guardian, I can make him go. Yeah, if you have an army or a police force, do you want to have your family member arrested to go to the nursing home?
Yeah, so this is California. We had everything for my mom, trust, power of attorney, doctor's letters, Alzheimer's diagnosis, everything, but she refused to leave her house. She was still cognizant enough, and he was pushing conservatorship, and he didn't tell me that it was going to take 6 months and $10,000, but luckily she ended up in the ER and went the psych ward route.
Yeah, and so the observation is that in a California case particularly, and that's somewhat relevant to this conversation because California is a little different. There had to be a conservatorship. That's one of the ways in which they're different. California uses conservator to describe what we would call a guardian as well as what we would call a conservator. I told you Connecticut is different. They have a completely different thing. They're called a conservator because it's Connecticut and they have to speak Old English. But both of those states use conservator of the estate and conservatorship of the person. And the other thing that's different about California is that same story probably would have been 8,000, 20% less, just to guess, in Arizona or most other states. California is notoriously expensive, but it would have been a significant expense. And the rest of the story rings very true in Arizona as well, including the alternatives. Your alternative was not an entirely pleasant one, but it was wait until mom has a psychiatric break and let's get her admitted to psychiatric care from the hospital, or until dad has his heart attack and we can do it from there. By the way, how many of you are veterans? If you are the ones who are going to have a psychiatric break or a heart attack, tell everybody in your family, drive past the Green Valley Hospital, past the Keno Hospital, get me straight to the VA. Is the care there that much better? No, but they have their own nursing home on site, and pretty much the only way into that nursing home is from the VA hospital. So you would like to be in the VA hospital when they're discharging you to nursing home care, just as an aside. The alternatives are to try to work things out, actually you can talk about mediation if you'd like. If mom is pretty cognizant, but she has limitations, maybe she would be willing to go talk to a counselor who could mediate the whole conversation for everybody. You're shaking your head no, and
That's why I wrote a book.
I totally understand that it doesn't work all the time, but sometimes it does. Sometimes people are just waiting for someone who is not their daughter or son to tell them that they need to go. And I hope that none of you are ever the person we have to convince. The law assumes that people function at this level, it's going along fine, it's going along fine, bam, you're incapacitated. That's not what happens. You all know that this is what happens. Where on that curve do we get to make decisions for you? And that's really a hard call. It's not up here at the shoulder. We hope it's not down here at the valley. It's somewhere on that very gradual curve. And that gradual curve might be 2 to 5 years long. So help us out by doing powers of attorney and trusting the people you name in the power of attorney to have your best interests at heart. Anything else you want to talk about guardianship and conservatorship? No? Let's talk about estate planning. So here's the very high-level question that people often, almost always have about their estate planning. Do I need a will or a trust? Do I need a will at all? Well, let's talk about something called intestate succession. It's just fancy lawyers' words. We lawyers, we love to throw Latin around like we knew what we were talking about. Most of us never took any Latin in high school or college, but we know a smattering of it from the legal terms. And we like to use it to prove that we're smarter than you. We're not really. But intestate succession just means dying without a will. So if you die without a will, does that mean the state gets your money or your probate is way more complicated? No, actually. The Arizona legislature has decided who you meant to name in your will. And so they've written a will for you. And they're right about 90% of the time. They've decided that if you're married, you want everything to go to your spouse. If you're not married, you want everything to go to your kids. If one of your kids has already died, they want that kid's share to go to his or her kids. If you don't have any spouse or kids, then they've decided you want everything to go to your siblings or their descendants. Actually, your parents and their descendants, but I'm guessing your parents have died. If you don't have any siblings or descendants or parents, then the Arizona legislature has decided you wanted everything to go to your grandparents and to their descendants, to your cousins, in other words, and their kids. And for most people, that's not all that far off, though I don't have a lot of people come to me and say, oh, I'm dying to leave money to my cousins. My cousins who ended up with my grandparents' silver and whatever. But the rest of it is not far off. There's one giant exception, then I'll.
Is there, if you're in another state and made a will, and now you're here, do you have to do something different?
So your will is, if you're in another state and you make a will, should we pick Iowa? Ohio, huh?
Ohio, yeah, that.
When I talk in Green Valley, I almost always use Iowa, and about 40% of the people say, how did he know? So Ohio, you wrote a will in Ohio. I don't know if that's where you wrote it, but you wrote a will when you lived in Ohio, and now you're here. Does that mean that these rules of intestate succession apply? No, your Ohio will is still valid. When your Ohio will was written, it made some different assumptions based on Ohio law, and you probably ought to have it reviewed. But here's the real thing. When you lived in Ohio and wrote that will 4, 8, 12, 22 years ago, a lot has changed in your life since then. If you say, yeah, my daughter got remarried and she has a different last name now. We don't need to redo it for that. But my son died and I don't like his ex-wife and his kids are losers and one of them is only 6 and you just started explaining to me why you need to update your will. Not because Ohio had anything wrong with it, but because a lot has changed in your life. Any estate plan you do, the estate plan itself has a life expectancy of about 5 to 10 years. We want to see you back every 5 years. We know that you won't get there in 5 years. So we say 5 to 10, but 10 is too long. If you think about what you were doing 10 years ago, I bet that you'll have to say, oh yeah, things were a lot different 10 years ago. I had a completely different relationship with my daughter-in-law and my grandkids, and our finances have changed a lot, and the kinds of assets we have are very different. A lot's going to change every 10 years. I want to go back to, before I leave completely, that intestate succession. I told you there's one exception to that: spouse, then kids, then siblings, then cousins. The big exception, and this is Arizona specific, not every state does this, is if you have children who are not the children of your surviving spouse. So you have a spouse and you have children who are not that spouse's children. Doesn't matter if your spouse has children that are not yours. Matters to his or her intestate succession, but it doesn't matter to yours. It's just if you have children who are not children of their spouse. The Arizona legislature doesn't know what to do about that. A lot of you who have that circumstance would say, I want everything to go to my kids.
You're all good.
A lot of people would say, I want everything to go to my spouse. Almost nobody would say, I want half of everything to go to my spouse and half to go to my kids. But that's how the Arizona legislature split the baby. So that's what intestate succession does in Arizona for people who have that circumstance of children who are not their spouse's children. For those people, you absolutely need to do a will. If you don't do a will, for most other people, it's bad, but it's not the end of the world. It doesn't really increase the cost of your probate. Well, it does in one sense. You won't have waived bond for whomever you name, whoever gets appointed as personal representative. So they'll need to do a little additional paperwork and maybe post a bond. So there's a little more cost in the probate. That's the real difference between wills and trusts, too, is probate. For most of you, the primary reason you would talk about doing a trust is to avoid probate. If you're a caregiver for someone who has a dementia or any kind of disabling condition, you might be talking about doing a trust in order to provide easier management for you while your spouse is still alive, and way easier management for your kids or your siblings or whoever's going to take over if you die before your disabled spouse. But other than that circumstance, the primary reason you would do a trust is to avoid probate. And then it becomes a cost-benefit analysis. Is it valuable enough to me to avoid probate that I'm willing to spend an extra $1,000, $2,000, maybe as much as an extra $3,000 to do a trust instead of wills and powers of attorney? Remembering that for most of you, the money that you save by avoiding probate won't do you a darn bit of good, because you're going to be dead by definition. So you're doing that for your kids. Is it worth it for you to do that for your kids at an additional cost during your life? Now, I can see a couple of puzzled looks. I know people in the room are thinking, but I already did a trust. So is he saying I should undo the trust? No. There's almost no circumstance in which it makes sense to undo a trust that you've already done. Even if today I would not tell you to do a trust. But if you did one in Ohio, different circumstances, different lawyer, different time, and you come to us in Arizona and say, should I just avoid this trust? We're going to say, no, let's work with it. It's probably easier to leave it there and still avoid probate, even though we might not have told you to do it now. In order to sign your estate planning documents, you have to be competent to sign. Generally speaking, that means you have to be able to identify what the lawyers call the natural objects of your bounty. In other words, can you tell us who your family members are? Do you have to be able to name all 6 of the grandkids and tell us how old they are and which kid they come from? No. It's okay if you say, I think I have 6 or 8 grandkids. That's close enough for us. We expect that you ought to be able to name your spouse and most or all of your kids. Sort of charmingly, when there's a kid who's kind of the black sheep, that's the one that reliably people can name. Yeah.
I have a trust in Washington. So now do I have to redo that trust in Arizona?
Yeah, so the question is, if you have a trust in Washington, do you need to redo it in Arizona? Oddly, that's exactly the question I got asked by somebody else before we started about Washington. And the answer is, maybe. You do need to go see a lawyer in Arizona with a copy of your Washington trust and statements showing how things are titled so they can tell you whether you really need to redo it. You probably need to do new powers of attorney, not because there's anything wrong with Washington powers of attorney, but because that's the one thing that does differ enough state to state that it's worth updating the powers of attorney. But that's not just because you had a trust in Washington state. If you just had a will in Washington state, what I'm really saying is whatever estate planning you did in Washington or Ohio or Iowa or wherever you came here from, if it's been more than a couple of years that you've been here, it's time to go talk to an Arizona lawyer about what it is you've done and what effect it would have. Does that mean you'll have to completely redo it? Not necessarily. I pretty frequently tell people, I'd rather you redid it, but there's no compelling reason that you have to. And any good lawyer will say the same thing. Yeah.
I just have a question. So if you've done your will and everything goes to your spouse, and then, everything, goes to the kids and this. So if your spouse dies, it goes to probate? It always does?
So my will says I leave everything to Rhonda. But if Rhonda dies first, Eric and Robin, my 2 kids, get everything. My will says that. Does my estate have to go to probate? Yeah.
It does.
Doing a will did not avoid probate. Doing a will just tells the probate court how to divide things. And if I have any assets that are in my name alone when I die, even if Rhonda survives me, it's going to require probate. Well, that's not quite true. Whenever I do these presentations, I warn people I'm going to lie to them, and I do it all the time. And that's because telling you the complete truth takes hours and hours. But this is an important one, so let me tell you the complete truth about that. My estate doesn't have to go through probate. If I have assets in my own name when I die, with no beneficiary designation, no joint owner, so long as in Arizona, the value of all the assets that are in my name alone is less than $75,000. There's a magic affidavit that Rhonda can sign. But of course, I don't own anything in my own name except my retirement accounts, and they all name Rhonda as the beneficiary. Everything else we own, we've been married for, guess what, 52 years. Wait, 52? Yeah.
You better know that.
50 was a big deal, and I sort of stopped counting then. So we own everything together. So if I die first, my estate's not going to have to go through probate, not because I didn't do a trust, but because her name's on everything. She's just going to take my death certificates around. That's why they tell you to get 15 of them. You need probably 3, but you'll be sorry if you have to go get more. But the better question that you could have asked is, if I do a trust that says that on my death the trust stays for my spouse's benefit, and if on his death then it goes to the kids, and he dies first, will there have to be a probate? No. Not because of the language, but because the trust owns the assets, and the trust says where they go. And that doesn't require a probate unless it says nothing about where the assets go.
What if it's already happened?
What if your husband has already died? Well, now if there are assets that are in your name alone and you haven't put your kids on, because that's an uncomfortable thing to do, to just put their names on it, and I would tell you don't do it. So don't put your kids' names on the account or title to your house. That's a mistake. We can talk endlessly about. So I see the things that people get to our website for, and we wrote a couple of articles a few years ago saying, absolutely do not put your kid's name on the house. And one of the most common questions we get, and one of the most common search terms that we see people coming to our website for is it okay if I put my daughter's name on the house? No, it's not okay to put your daughter's name on the house. Just don't do that. People do it all the time anyway. So if you don't put your daughter's name on the house, though, if it's in your name alone and your other accounts don't have beneficiary designations, they're in your name alone, then yes, we'll have to probate your estate. Having a will doesn't change that, because the will just tells the judge, the probate judge, where to send things. If they're in a trust, then we avoid probate. And that's why you might create a trust instead of a will. Yeah.
I have a question. You said you own everything together. We own everything together, but you have IRAs that is in his name.
Yeah, so retirement accounts are kind of a special case. You can't jointly own retirement accounts, but the IRA custodian just won't let you get by without having a beneficiary designation. So probably if one spouse has retirement accounts, IRAs, 401ks, 403bs, whatever they are, probably the other spouse is named as beneficiary. And so we won't have to probate your estate unless the spouse who's named as beneficiary dies first. Have you all checked to see if you have alternate beneficiaries on your IRAs and 401ks and 403bs? If you haven't, then, yep, sure enough, we're going to have to probate the second spouse's estate.
You could put the kids on it then.
You can put the kids on as, assuming that's who you want to receive it, you could put the kids on as beneficiaries, as alternate or contingent beneficiaries, not as first beneficiaries, probably. And let me just warn you that there's a lot of nuance about who should be the beneficiary on your retirement accounts. So usually it ends up being the spouse, but don't take that as absolute truth in all cases. Yeah.
How about making your children co-trustees?
How about making your children co-trustees? What an excellent question. Thank you for that question. I'm a big fan of that, and I suggest it all the time. And that's because I know that curve. I've spent 49 years looking at that curve. And I know that there's that long block of time where you are losing your capacity, but you're not at a point where anybody can get a doctor's letter saying you're incapacitated. And what I'd love to see is a family that's so healthy and well adapted that the parent, by degrees, says, why don't you take over this task? Why don't you take over this task? Why don't you take over this task? As they slide down that slope, so there's no cutoff where suddenly the kids are in charge. It's just a natural progression. Does require you to trust the kids and communicate, but in a good, healthy family, that is. ACEs. That's my very favorite answer. Yeah.
If you leave your son as a beneficiary and something happens to him, does that automatically make his wife your beneficiary?
Another excellent question. So the question is, if you leave things to your son or daughter and they die, you say something happens to them, but I'm sort of blunt. They die. They don't pass away. They just die. I tell my staff whenever I read an obituary that says he lost his valiant fight with cancer. No, cancer kicked his butt. People die. So when your son dies, does that mean his wife inherits the share? Well, it depends on what your will or trust says. You can say that. If you really love your daughter-in-law, you can say anything that would go to Ben would go to her instead. If you don't say, Arizona law says, we presume that you intended to keep it in the bloodline. So it doesn't go to the spouse, it goes to his kids. If he doesn't have any kids, it doesn't then go to his spouse, it goes to his siblings, if you don't say otherwise. So if you feel strongly, you want to say what you want to happen, whether that's in your will or your trust. But if you don't say anything, the presumption is it stays only in the bloodline. Hey, I want to go back to one thing. I said there are three elements to the test for capacity. I told you one is identifying the objects, natural objects of your bounty. The other two are you have to be able to understand the kinds of assets you have. Doesn't mean you have to know that you have a $100,000 CD at Notre Dame Federal Credit Union and a $42,000 account at Charles Schwab, just that you know you have some money and maybe some land. So it's a very generalized understanding of you having assets. And the third part is you have to understand that you're making a will, not signing a shopping list or a change order on the construction on your house or something. So it's a pretty low bar for you to have capacity to make a will. Same thing for powers of attorney, by the way. It's not the same exact test, but they're pretty low bars. So somebody who couldn't manage their own finances still might have the capacity to create a trust to manage their finances or give a power of attorney to somebody to manage their finances, to do things they wouldn't be able to do. The mere fact, this happens all the time, the mere fact of a diagnosis of a dementing illness does not preclude you from signing powers of attorney or wills or trusts. I had a client, I dearly loved him, and when his wife was diagnosed with dementia, the two of them came in to update their documents, and I said to her, so are you still wanting to name him as your agent? And she said yes. And I said, and do you still want to name her as your agent? And he reached in his pocket, pulled out a pill bottle, and set it on the conference table and sort of pushed it toward me. I said, are you telling me there's something in this pill bottle that's going to answer that question? He said, without saying any words. I picked it up, and it's a prescription for Aricept. And I said, so your wife has a diagnosis? And he says, without saying any words, he doesn't want her to know that he's telling me. I don't know how he thought he was getting away with that. It didn't matter. They could do whatever they wanted, both of them, because she clearly could understand what we were talking about and what was going on. And I asked her, ultimately, are you okay if he names your kids as his agent before you because he's worried that you won't be able to handle his decisions? And she said, oh yeah, I've been diagnosed as early dementia, and he's... If somebody can say that, they have the capacity to sign their documents. Yeah?
One more question about trust. Right now, you may have made a revocable trust, but your partner has been diagnosed with dementia. Should you consider making it irrevocable?
Yeah, so you think that's a trust question, but it's really a long-term care planning question. So your segue was perfect.
Okay.
I'm going to tell you the answer is probably not, but probably not. And you said partner. Is that spouse?
Spouse.
Yeah, okay, because it's a different answer if they're not a spouse.
Okay.
So this is a huge topic. We are almost at the 1 hour, and this is what I expected I'd spend most of my time on. I don't have to be anywhere until I have to pick up my dog at 5 o'clock. So She's cute as a bug, by the way. Anybody Corgi fans in here? I have a cardigan Welsh Corgi. She does. Her dinner time is 5:30, and at about 5:25, she comes over to me and says, and she'll do that to whoever's next to her if I'm not there in time. She has a very good clock. I can keep going, and I don't want to hold you captive if you all say, I only signed up for an hour, I'm out of here. I won't have my feelings hurt, but I'll talk a little bit about long-term care costs, and then probably we'll never get to my favorite topic. Long-term care costs. First of all, let's talk about some numbers. How much does it cost in Pima County, Arizona in 2025 to keep somebody in a nursing home? Anybody happen to know, have a guess about what that number is?
Nursing home, assisted living, yeah.
Let's start with nursing home, if anybody knows.
9,000.
9,000, 8,000 or 9,000 is probably a very good figure. And probably, because I'm always a little behind the inflation curve, probably 9,000 is better than 8,000. How much does it cost to keep somebody at home if they needed nursing home level of care? It's higher, quite a lot higher, on the order of 12,000, higher. Because there are economies of scale of only having enough nursing staff in a nursing home to cover, one nurse per 4 patients or whatever it is. When you're at home, you have all of that, and now the truth is, most people who are cared for at home, a spouse or another family member is doing a pretty significant part of the care cost. But still, keeping somebody at home in nursing home level of care is on the order of about $12,000 a month without counting all the costs of maintaining the house. Okay, so if you're thinking it'll be cheaper to keep me at home, you're just wrong. It will not be cheaper to keep you at home, and it certainly won't be easier on the spouse who does most of the caretaking. Now there's other alternatives, the assisted living. You want to throw in an assisted living number?
About 10.
My wife's in assisted living.
So assisted living is widely variable, but 10 is probably in the range. Not far off today from nursing home costs. 8 to 10, I would say. But independent living and adult care home, the two step downs from assisted living, I've seen people in current months paying $4,500 or $5,000, but not really much less than about $4,500. And I'm talking about demented adult patients, not the mentally ill who are ambulatory and have management issues, and not the developmentally disabled who have Division of Developmental Disabilities staff members overseeing them. They're both special cases with different numbers. But for somebody who is senior, demented, requiring some sort of home care, we're talking about a number between 5 and 10 or higher per month, depending on the level of care. So you're all totally okay, right, with writing a $10,000 check every month for, yeah.
Yeah, do you know, 'cause I dealt with this in Texas, but anything about being able to take the cost of nursing home or memory care rent off of their income tax?
So the question is whether you can deduct the cost of nursing home or independent living or assisted living from your income taxes. Yes, you can, as long as you have a doctor's letter saying that that care is required. And then you can take off all the costs, the room and board portion of the cost and everything. But that's sort of weak tea for somebody who's writing a $10,000 check a month. Oh, great, you get to, but only to the extent that it exceeds 7% of your income. So most of the people that I deal with have a very hard time getting up to a deduction of any size, even if they are paying a lot of nursing costs. So it doesn't really help as much as you might think. But yes, you can deduct it.
Are you saying there's a deduction, have to be a certain deduction before you can take it off?
The medical deduction on your income taxes, your medical expenses have to exceed 7% of your income before you can make the deduction. So it doesn't help for most people. It doesn't help very much. Long-term care insurance? Anybody bought long-term care insurance? Yay, you?
It'd be fine if you were 20 when you bought it.
It would be fine if you were 20 when you bought it. The ideal age, according to people in the long-term care insurance business, for somebody to be a new long-term care insurance customer is about 45 or 50. The average age of new enrollees, last time I looked, it's probably changed actually for reasons I'll explain. The average age for new customers is 70. So that's kind of too late. It's not horribly too late. One of the reasons it's 70 instead of 80 is because there reaches a point where your conditions prevent you from getting coverage. If you could get coverage regardless of your conditions, the average age of onset for LTCI, long-term care insurance, would probably be 80 instead of 70. The long-term care insurance industry is going through giant upheavals. People are leaving the market. Existing policies have huge increases in premiums. A lot of people have reduced their benefits as a way to keep the premiums affordable. And just looking around the room, well, I'll use myself as a marker. I'm 73 this year, and I'd be a terrible candidate for long-term care insurance now. And I'm pretty healthy and would probably pass whatever underwriting they did, but I'm the wrong demographic to be buying it, and I expect most of you are too. But if you already have it, again, yay you, don't cancel it just because it's expensive without talking to somebody about it. The other thing about long-term care insurance is it is a nightmare to collect on. The insurance companies make you prove everything over and over and over. You go through 3 months of paperwork to get the first month in the assisted living facility covered, and then it's time for you to do it again for 3 more months for the next month. I mean, it's just endless cycles of paperwork. So what is there out there to help you? Well, there is some government assistance to cover the cost of long-term care. And this is where we're going to go really high level. First of all, there are a couple of programs that have a tiny sliver of the care. The VA, the Indian Health Services, Civil Service. But the ones that people most think are going to be helpful are Medicare and Medicaid. Medicare is not going to help you. First of all, most people won't qualify for any Medicare coverage for their long-term care because of the way the diagnosis and condition is coded. But if they do, there's a 20-day period of coverage, and then everybody says, oh, no, wait, there's another 100 days. Yeah, there is, at more or less the full cost of nursing home care. So the deductible means that you pay most of the cost of nursing home care, and then you're done. That's it for Medicare. So Medicare is almost, but not quite, worthless for long-term care purposes. You may have noticed the growth of rehab centers. And how frequently people go to rehab centers when they might once have gone to nursing homes, and that's driven by Medicare. That's in order to get them covered in a rehab center with a slightly different code than if they were in a nursing home. It used to be that those functions were all done in nursing homes. And that means that what we have to pay for to assist with your long-term care is Medicaid. That's it. Well, we don't have Medicaid in Arizona. We have something called Access, the most cruelly misnamed program in government history, because the whole point of Access is summed up in its real name, which is the Arizona Health Care Cost Containment System. They might have named it the Arizona Good Health Care for All Citizens program, but they didn't. They named it Cost Containment. The whole idea of Access was, what's the smallest benefit we can give the citizens of Arizona and still qualify to get federal matching money? We were the last state to join Medicaid for that very reason. Our legislature was terrified that you all would become dependent on the government, and they didn't want to have that happen, so they just kept you from having any access to Access at all. When we got Access, it was what was called a waiver program. It was a way of moving the administration and management of healthcare costs into an HMO model. And our legislature said to the federal government, we don't see how we can do that for long-term care. So we would like to just have long-term care and also mental health care and also the care for the developmentally disabled carved out of access. We just won't cover them. And the federal government said, nope, we'll give you your waiver, but you've got to have a program that looks just like Medicaid for those three populations. So those three populations get folded into a program. It's a subset of access called ALTEX, the Arizona Long-Term Care System. So for our purposes today, those three terms, phrases, acronyms are identical. They're interchangeable. Medicaid, ALTEX is just Medicaid, Access is just a variant of Medicaid. The people who pay for long-term care are the Arizona Long-Term Care System. So if you see things talking about getting eligible for ALTEX, sometimes using the word Medicaid, it's not a mistake, it's not wrong, it's just another term for the same thing. So the question is, how do you get on ALTEX? Well, there are 5 things you have to meet in order to get on ALTEX. 2 of them I didn't even put up here because they're really easy. One is you got to be a citizen, big surprise, or a resident alien. You have to have status, a green card or some status, but we'll just call it for the moment citizenship. The second one is you have to be a resident of Arizona. That one's the easiest one of all. That means you have to be physically present in Arizona with no intent to leave. If you are demented enough to be in a nursing home, you can't form the intent to leave probably, and so the physical presence is really all they look at. If in the interview, the nurse who conducts the interview says, so if we let you out of here, what would you do? If you say, go back to Ohio, well, maybe that's a problem. So just make sure you're there when your spouse is being interviewed. So you can say, oh, honey, you're not going back to Ohio, you know that. So those 2 are usually pretty easy. The third one is a little harder. You have to be medically eligible. So ALTEX provides care in the home and in assisted living, and even theoretically in an independent living and definitely in adult care home settings. But the level of care you have to need to qualify for ALTEX is nursing home level of care. You have to have limitations in all of your activities of daily living. Activities of daily living are the ability to dress yourself, the ability to feed yourself, the ability to transfer from bed to wheelchair or bed to walker, the ability to ambulate, the ability to transfer from walker or wheelchair to the toilet, and the ability to toilet. Those are all things they test in determining whether you medically qualify. I'm going to ignore that for a minute. That's frequently a problem for somebody who's pretty together, and of course, when they do the interview, which they don't do in person anymore, but when anybody asks your spouse or your parent, so what'd you have for breakfast this morning? They say, eggs. They were great. Did you feed yourself? Oh yeah, I always feed myself. Even though they had cereal and somebody had to come and hand it to them. So don't let them fill in the blanks. You got to fill in the blanks. The big issue is asset and income eligibility. So for a single person, don't want to terrify you, I'm only talking about a single person. Single person can't have more than $2,000 in available resources. Plus unavailable resources, their home, their car, their household effects, a little bit of money set aside for a burial. That's actually not quite correct. A little bit of money set aside for a funeral, the plot, the casket, the opening and closing and lining. There's no limitation, but there's a $1,500 limitation on prepaid funeral costs. And a handful of other things. Those are the big ones. So you can actually have quite a lot more than $2,000, but remember we're talking about a single person. The second financial test is income. So again, a single person has to have income of less than 3 times the maximum SSI rate. I knew there was something I was supposed to do before I drove down here. I was supposed to look up the 2025 SSI rate and multiply it by 3 in my head so I'd get it right, and I forgot to do that. But the SSI rate is 972. No, that's not right, but thereabouts, $970, $970-ish dollars. So 3 times that is $2,800, $2,900. That's how much you can have in income and still qualify for ALTEX. Both of those were for single people. That's Social Security. Yep. And by the way, they add back your Medicare premiums and anything else that's being deducted when they calculate it, just to add insult to injury. So it's pretty hard to meet the income test. Now, those were for single people. The rules are different for married couples. And this is where it gets really complex, unnecessarily complex. So let's do the asset side first. Now let's do the income side first, because it's easier. The income side, one of the rare cases where you get to pick column A or column B, whichever one is better for you. Either the institutionalized spouse's income has to be below that $2,700, $2,800, whatever it is, for all income that has his or her name on it. So if it's an annuity payment that comes to both of you, it gets added in. But if it's an annuity payment that comes to you only, it doesn't get added in. If it's his Social Security, it gets added in. If it's your Social Security, it doesn't get added in. And if he's below the magic number by that calculation, great, he's eligible. The second way to do it is to add up everything that comes in either of your names and divide by 2. And if that number is below the $2,800, whatever it is, number, then great, he qualifies. What that effectively means is that so long as the higher earning spouse is the one in the nursing home, let me try that again. So long as the lower earning spouse is the one in the nursing home, they probably qualify. But if the higher earning spouse is the one in the nursing home, high likelihood that they don't qualify. I'm going to tell you a phrase that I want you to immediately forget. Because people grab this and they run with it and they think it's going to solve problems. It solves this problem. It solves the income cap problem. It solves no other problems. And if you come to me and say, I heard the magic phrase, you told me to forget it, but I remembered it, I want one of those, I'm going to tell you not till you're in the nursing home. There's no earthly reason for you to do it until one of you is actually in the nursing home. It's not something you need to plan in advance for. You ready for a magic phrase? Any of you know what it is already? It's Miller Trust. A Miller Trust solves that problem and that problem only. It's named after a Colorado case involving a man, I think man, not woman, last name of Miller. That case went up to the Court of Appeals in Colorado. And so when the federal legislature enacted their current laws, they said, well, we better carve out those things they can do in Colorado. And now we can do them everywhere. The much harder problem is the asset limit. For a married couple, there's an intent to keep the community spouse from having to impoverish themselves. So they're allowed to keep some of the assets in addition to the $2,000 the institutionalized spouse is allowed to keep. This is the part that's just horribly complicated. So let's just say some number, depending on how much money you had when your spouse went into the nursing home, some number between $30,000 and $150,000 you're allowed to keep. But there's that cap of about $150,000. So you get to keep that, he or she gets to keep $2,000, you have to be spent below that in order to qualify. If you call up Altex and say, we have too much money, my husband just went in the nursing home, I would like you to cover his care, but we have more than $152,000, what are we going to do? They'll say, spend it down on his care, let us know when you got it below $152,000 and we'll talk. It's not like they take the money, it's not like the nursing home takes the money, it's just you don't get any subsidy, you don't get any help, so you're on your own with the nursing home or the assisted living facility or whatever until you get below that magic number. It's correct that spending it down is one of the big choices, but spending it down on, and I'm going to put your husband in the nursing home, even though it might be you're the husband and it's your wife in the nursing home, so I don't have to keep saying his or her. So it's correct that you may have to spend down, but it doesn't have to be just on his care. It could be on your round-the-world cruise. You could take a round-the-world cruise, so long as when you dock back in Los Angeles Harbor, your assets are below $152,000, and you have good receipts to show that you didn't give it away. then your husband will qualify. They don't judge the quality of your expenditures, just the fact of your expenditures. You can't give it away to your kids. Making gifts doesn't work because when you apply for All-Tex for your spouse, they're going to say, oh, by the way, have you given any money away in the last 5 years? Yes? Oh, well, how much and when? Oh, we'll calculate how many months we think you could have paid for long-term care costs with that money, and we will disqualify you for that many months beginning to run when you've already gotten down below the $152,000 level. So making gifts is just not an attractive choice, unless you're prepared to last 5 years, in which case then when they ask, have you given anything away in the last 5 years, you can say, oh no, it was five years and 1 month ago. I'm golden. No, I haven't given anything away. But then I got to ask you, what have you been living on for the last 5 years after you gave most of your money away 5 years and 1 month ago? So gifts just don't very often work out.
If you spend that money like on your home for improvements.
What a great idea. So the question is, what if you spent the money on your home for improvements or paid off the mortgage or bought new refrigerator or how about your car? That 1996 Oldsmobile Cutlass, it's about time to replace it. You can get a 2025 Tesla and install the charger in addition. Absolutely, you can do all those things because what you've just done when you do that is you've converted available resources to unavailable resources. There is a limit on how much your home can be worth, but it's pretty high. So probably you can do all those things. There's a lot of stuff you can do to plan, and I don't want to try to do all of them, all of the things you can do. But there are things you can do, particularly for married couples. There are far fewer things that a single person can do. That was the very high level of All-Tex. Do you have a question? Any other questions? Do you want to stay 5 more minutes and do my fun part? Anybody know about the Orange Form? So the Orange Form is a thing unique to Arizona. A lot of other states have something similar called POLST. POLST stands for Physician's Orders on Life-Sustaining Treatment. The Orange Form was invented before POLST was a thing. And so we didn't have POLST, we adopted the Orange Form instead. A lot of people call the Orange Form a do not resuscitate order. It's not really. A POLST is a do not resuscitate order. A do not resuscitate order is a doctor's order. And the Orange Form is your instruction. I don't want to be resuscitated if I stop breathing, if I have cardiac arrest. The Orange Form says if I'm shopping at, I used to say Sears, but there isn't a Sears anymore. Where do you go shopping? Walmart. If I'm shopping at Walmart and I collapse at the cash register, when the paramedics come, I don't want them to pound on my chest. If that's you, the Orange Form is very good. But a lot of people that I know say, well, I don't want to be kept alive on tubes in the hospital, but I'm thinking maybe I want to be resuscitated after an auto accident or a cardiac arrest. Then I would say, don't sign the Orange Form, because the Orange Form only speaks to paramedics and emergency room physicians. It doesn't say a thing about the nursing home or the hospital or any of the places where you think you might be hooked up to tubes. So you're not an Orange Form candidate if you're not prepared to say, don't resuscitate me when I collapse.
Strap it to your chest then, so if you fall, it's like...
Can you strap it to your chest? I was on the legislative committee that, I was on the committee that advised the legislature on the creation of the Orange Form. And we had a public hearing where somebody stood up and said, there was a doctor who's one of my favorite people in the world who was on that committee with me, sitting right next to me. And this person said, Dr. So-and-so, I'm going to have my Orange Form tattooed on my chest. What would you do if you saw that I had this Orange Form tattooed on my chest? And he said, I would rip open your shirt, I would see the Orange Form, I would pause a moment to admire the handiwork, and then I would resuscitate you. Because the Orange Form has to be on orange 8.5 by 11 paper. and has to be signed by you and signed by a medical provider. So the thing on your chest can never qualify unless you're prepared to do your own. That's too scary to even contemplate, and to get your doctor to do it too. But you can wear a bracelet, and you can carry a wallet-sized version in your wallet. We don't have pulsed in Arizona because of the orange form. We probably ought to just adopt the pulsed paradigm, but we haven't done it. I already said that an orange form is not a DNR. That doesn't mean you can't have a DNR. You can have a DNR, and that might be appropriate. More important for most people at the end of life is a do not hospitalize, DNH. If you can get some kind of order saying don't take this person to the hospital, particularly to be posted at the foot of their bed at the adult care home or the assisted living facility or the nursing home, if you can keep them out of the hospital, the odds of them being resuscitated are way lower. It is, as a legal matter, there's no difference between withholding resuscitation or intubation and withdrawing it. But emotionally, there's a huge difference. So once they are on the tubes, it's way harder to take it off than it is to keep them off the tubes to begin with. And that's what DNI is, do not intubate. So somebody who's out there in a facility whose death is anticipated, they should be on hospice, because hospice is really good about the mechanics of this. They should have a do not hospitalize and a do not intubate and a do not resuscitate order.
I've got the orange form, I don't have the other two. Where can I get the other two?
You can't, so the question is, how do I get a DNH and a DNI if I already have the orange form? First of all, again, your orange form is not a DNR, but you can't go out and get these forms because they're doctor's orders. All of them are orders from the doctor. So what you need is a doctor to say, I will order that you not be hospitalized. Now, the odds of you getting that after having walked into this room today are really close to zero. They're not really zero, but they're really close to zero. The doctor is going to say, no, that's for somebody who's in a facility whose death is anticipated. I'm not prepared to enter that order for you because I don't know how it is you're going to present.
Okay.
But one of the nice things is most doctors will ask if the patient has a DNR, etc., before they will resuscitate. So if you're brought into the hospital and you have a family member there and they say they don't want resuscitated, most of your physicians will not.
So the observation is that physicians will usually ask if there's a DNR before they resuscitate. I'm going to qualify that. I'm going to say many physicians ask, but in the heat of the moment, the people who are actually getting you on the train to get to resuscitation are paramedics, not doctors, and they think their job is to save lives, not to figure out what documents there are. So that argues for not just a living will where you say, I want to not be resuscitated, but a healthcare agent who can run up and down the halls, waving the forms around, screaming bloody murder, and poor choice of words, I guess.
So are you saying that the orange form, DNH, DNI, DNR, has to be on the physically on the person? We're a very mobile society.
Yeah.
No, very good question. Am I saying that all these things have to be physically on the person? First of all, the odds of a mobile person out in the community having a do not resuscitate, a do not intubate, and a do not hospitalize, again, are very remote, because no doctor is going to enter those orders because they don't know how they're going to present to the system. And they're also going to say, but I'm not treating him for that thing. I'm this kind of doctor. But the orange form does need to be available because, again, it's addressed to the paramedics and the emergency room physicians only. So the only time it ever has any importance is while you're out in the community. So yeah, you need to have it somewhere. The wallet-sized version or the wristband is good.
They're not going to check your wallet before they come in.
They're not going to check your wallet. So you need to only travel with your spouse who can find your wallet and wave that orange form.
Where do you get
Yes, there's always a chance they might resuscitate.
Where do you get the wristband for the orange form? It used to be that there were a couple of people who sold them, and I could tell you one of them was engraved on metal and painted orange, but there was no demand, and so they kind of went out of business. You can Google Arizona orange form wristband and see if you can find something.
You can get a medical bracelet that will say do not resuscitate.
You can get a medical alert bracelet that can say do not resuscitate, but that has no effect for the paramedics. And the paramedics, again, they're the people who are going to say, our job is to save lives. We're not going to judge the validity of these documents.
And my orange form is hanging on my refrigerator.
And that is hanging on the refrigerator, and that is where the paramedics are expecting to look. Again, at that hearing, one of the members of the committee was a legislator from Sun City, thank you. Whew, man, this old age is really catching up with me. And he said, as soon as we adopt this bill, I expect I'm going to drive down through my district and there are going to be orange forms on every garage door in Sun City. And whoever was being a smartass, wasn't me that time, said, well, Mr. Representative, you should tell them to move them inside to their refrigerators because that's where the paramedics are told to look. Look, that's not required, that's just where they're likely to look. Wait, hang on.
My initial question is, orange form is on my refrigerator, but I'm here.
Right.
And if I fall over,
You can have-
none of you know I have an orange form.
You can have both the refrigerator version and the wallet card version. The wristband is not an orange form. It just says, I have an orange form. But the orange form, the wallet size is an orange form. You can have two of them.
Yeah, one more bullet.
One more bullet, and then I'm done. And that's about cremation, burial, and now composting. Arizona now allows human composting. I don't know of any funeral home that has been set up to do composting, but there's one in Marana that I think will probably be the first one in southern Arizona and maybe in all of Arizona to offer it. If you're interested in it, look into it. It's a kind of a convoluted process, should be less expensive, and it uses far less resources than any of the others. People who are really resource conscious often say, I want to be cremated because I don't want to have all of those chemicals stuck in the ground. And it turns out that it takes more carbon to cremate you than it does to plant you. So the composting is beginning to look attractive. If you want to be cremated or composted or any of the other alternatives other than traditional burial, you should make that clear, sign a document indicating it, pay for it. Vastly improves the likelihood that your choices will be carried out if they've already been paid for. Vastly increases it. And make sure your kids know that you want it and they will sign. Funeral homes often require the consent of all the next of kin before they will allow a cremation. So if that's important to you, make the plans. And that was my last bullet. Thank you all for your patience.
Thank you. Fleming, very much. Yeah, really appreciate it. We got more than we bargained for here. We got the full deal. And just to also identify Pam Chambers in the back. Pam is the coordinator for the Stress Busters program, support program. So Pam will be with us, and so feel free to ask her questions. Mr. Fleming has offered to hang around if you've got individual questions. So can ask for more generosity than that. Thank you very, very much.
Thank you for bearing with me.